My name is John Raffensperger with Law Center for Better Housing, and we're going to talk a little bit about the eviction process and specifically how that process gets started and what tenants can do to stay in their homes and to access resources during those early stages of an eviction case. So let's just start out with a question. Fact or fiction? A tenant should go to court if they receive an eviction summons. That's a fact. Court can be a scary place and a stressful place for tenants, but it's very important that if a tenant gets a summons that they do go to court. If the tenant doesn't go to court, then the landlord is going to automatically win their case because the tenant isn't there. They can get an eviction order and a judgment. If the tenant does go to court, the tenant will have opportunities to connect with free legal help and resources, possibly mediation, possibly rental assistance to help them resolve their case, get their case dismissed, settled, and preserve their rental record so that they can access secure housing in the future. Let's have another question. Fact or fiction? Once a tenant receives an eviction notice, no help can prevent an eviction. That's right, that's fiction. An eviction notice is just the start of what can be a long process. And tenants will have an opportunity to fix the problem that is raised in the eviction notice, or if it can't be fixed, to work out a solution with their landlord that allows them the time to move with dignity or an opportunity to correct the problem and stay in their home. Let's talk a little bit about evictions in the court process. What we're going to cover here are a few topics. First, where renters can get help if they're behind on rent but haven't received a summons. We'll also talk about what renters should do if they receive an eviction notice or a summons. We'll talk about how tenants can prepare themselves for eviction court. We'll talk about what happens in court, and we'll talk about what tenants can do to get connected with the resources that are available, whether that be legal aid, mediation, or other resources throughout the process. So before we get started, we should first note that this is a presentation covering eviction in Chicago. While eviction in other areas of Illinois may be similar, there are local ordinances that come into play that can mean that there are different requirements here than there are in other places in the state. So first, let's ask the question how a tenant can get more information if they're worried about an eviction, but they haven't gotten a summons yet and a court case has not yet begun. Well, fortunately, there are a number of resources available to Chicago renters to get more information about the process and to start accessing help even before they get into court. Rentervention.com is a website that tenants can visit to get information about eviction and about the court process, and also to get connected with legal volunteers that can help them for free to assess their case and figure out the best next steps. That's rentervention.com, or tenants can text HI to 866-773-6837. Another resource that's available for tenants before the eviction process begins, the Cook County Legal Aid for Housing and Debt Hotline. That's a number that tenants can call. It's 855-956-5763. And tenants can call that number to learn how to get help with their housing and debt problems, access rental assistance, or access mediation services to help them work out their problem with their landlord before the formal eviction process begins. So if we're talking about eviction, that can be a confusing topic, and not everybody agrees about what that should mean. Eviction is not just one thing, it's a process that has a number of steps. And the first step in that process is the landlord telling the tenant that they want the tenancy to end. The landlord needs to do that by giving the tenant a formal written notice telling the tenant what the problem is and why the tenant needs to move out and when. It is illegal for landlords to lock tenants out of the property or to force them to move without going through the formal eviction process, giving them a notice and going through a court case. And we'll talk a little bit more about that later in the presentation. In many cases, renters will have an opportunity to fix the problem and stay in their homes, and we'll also talk about how renters can cure, which is how we refer to that fixing the problem step. So what are the reasons that a renter could receive an eviction notice? There are generally three reasons why tenants can get a notice from their landlord saying that they need to move. The first and most common reason is that the tenant is behind on rent. So if the tenant hasn't paid rent, the landlord can give them a notice saying, you need to pay me this rent within a specific amount of time, or you need to move out of the property. The second reason why tenants receive a notice is because there's some violation of the lease the landlord is claiming other than the non-payment of rent. So the landlord could be saying, you haven't complied with your lease because, for example, there's an unauthorized person in the property, or maybe you have a pet when pets aren't allowed. That notice generally gives a little bit more time and more opportunities to fix it. Finally, sometimes landlords will give a tenant a notice for no cause at all, and that's simply a notice that the landlord, for one reason or another, does not want to renew the lease or continue the tenancy. So how much time does a tenant have to resolve the notice or move once they receive one? Well, that depends on what the notice is for. So if the notice is a notice for non-payment of rent, saying that the tenant's behind, the tenant in Chicago will typically have 5 days to make that payment. They must have at least 5 days. Sometimes the notice will give them more time. If the notice is for some other violation of the lease other than the non-payment of rent, the tenant will have at least 10 days to either fix that problem, if it can be fixed, or to move out of the property. And then if the landlord is ending the tenancy simply because they don't want to renew the lease or for some reason or another they want the tenant to move out, how much time the tenant has depends on how long the tenant has lived in the property. If the tenant has been there for fewer than 6 months, the landlord only needs to give them 30 days notice before asking them to move or deciding to raise the rent in the property if the tenant wants to stay. If the tenant has been there longer than 6 months but fewer than 3 years, then the tenant is entitled to twice that. They get 60 days notice in writing if the landlord wants them to move or to raise their rent. And then if the tenant's been there a long time, if they've been there for 3 years or more, they're entitled to 120 days notice, or about 4 months, if the landlord wants them to move or wants to raise their rental rate. What can a tenant do if they get a notice from a landlord? Well, in many cases, the tenant has an opportunity to what we call cure the problem that's raised by the notice, or to try to fix it so that they can stay in the property and prevent an eviction proceeding from going forward. If a tenant's behind in rent, as we mentioned, the notice has to give them 5 days at least to pay and catch up. So if the tenant can pay the landlord all the rent that's owed within those 5 days, then the notice is waived and the tenant can stay in the property. If more than 5 days have gone by and the tenant has the money, they can still try to pay the landlord. And if the landlord accepts all the money that's due, even if it's past 5 days, then again, that notice is waived and the tenant can stay. It used to be the case that a landlord, after those 5 days had expired, could simply refuse to take the money and go forward with an eviction case if they wanted the tenant to move out. But as of 2020, the law in Chicago has changed in an important way, and most tenants in the city now have what's called a one-time right to pay and stay. If the tenant does have that right because they live in a property to which the landlord-tenant ordinance applies, then if they pay the landlord all the money that's due, plus any costs that the landlord has incurred to start the eviction case, other than what they pay their attorney, the landlord has no option but to take the money, and they have to continue the tenancy, and if an eviction case has begun, they need to dismiss it. We call it a one-time right to pay and stay because a tenant can only use that option one time with any particular landlord. If they cure using their one-time right to pay and stay and then fall behind later, then that won't be an option for them a second time. But it is an important right for tenants to know that they have, and for landlords to know that exists as well. It's important for tenants to know that if they're going to try to cure non-payment, only full payment is going to suffice. Tenants cannot make a partial payment and expect to stay even if the landlord accepts it. The landlord can still continue the eviction process. And it's also important for tenants to understand that if the tenancy is being ended for no cause, not for non-payment of rent, the landlord is allowed to take the rent and keep it up until the time that the tenancy is supposed to end. It's only if the landlord continues to accept rent after they've said the tenancy is over, after that 30, 60, or 120-day notice period, that they would be giving up their right to proceed with eviction. So another question that many tenants have is if they cannot pay the rent, there are resources available to them to help them catch up. There are some resources. Where they exist really depends on who has money at the time, but we've provided here on this slide a number of places that tenants can contact if they want to try to get rental assistance to help them pay the back rent and stay in their homes before an eviction case has begun. Another question that often arises is what a tenant should do if the landlord tries to make them move out of their home without going through the eviction court. Unfortunately, it's not uncommon in Chicago for landlords to try to take matters into their own hands and force their tenants to move out without the time and expense of a court process by changing the locks, by turning off the utility service, or by taking any number of other steps to make the property uninhabitable so that the tenants have no option but to leave. This is referred to as a lockout, and it's unlawful in the city of Chicago. If a landlord tries to use any of these means to force a tenant out without going through the legal eviction process, the tenants can call the police at 911, and the officers should be able to help the tenant resolve the situation. To learn more about the rights that tenants have in a lockout situation, tenants can call the Department of Housing Renters' Rights Information Line at 312-742-RENT, or they can call the Metropolitan Tenants Organization's hotline at 773-292-4988. The next step in the eviction process after a tenant receives a written notice saying that the landlord wants to terminate their tenancy is the start of a formal eviction case. How does that work? The requirements for a landlord to start an eviction case are that they first have to file what's called a complaint with the court, which is a document explaining why the landlord has the right to take the property back or a right to get a judgment for rent against the tenant. The second thing the landlord needs to do is to give the tenant formal notice that a case has begun and that they need to come to court. This formal notice is called a summons, and it's a document that would tell the tenant that a case has been filed and give them the date and time of a court hearing and how to access the court. How is the tenant going to receive that formal notice? That can happen in several different ways. First, the summons can be personally delivered to the tenant by a sheriff's deputy or by another person who's been appointed by the court to deliver papers. The papers can be left with another person who lives in the property over the age of 13, who's told that these are the court papers to deliver to the defendant in the case. Or, and it's important for tenants to understand this, the service can be accomplished by what's called posting, which means that the notice about the court case is posted in public locations in the city, and a copy of the summons is mailed to the tenant. It's unfortunately the case that sometimes tenants don't receive that mailing and are unaware of a court case that's where service has been accomplished by posting. So it's important for tenants to pay attention, to read their mail if they think that they might be in danger of eviction. Fact or fiction? The eviction court can only enter an order against the tenant if the tenant gets the court papers in their hand from the sheriff. Well, unfortunately, as we've just learned, that's fiction. The tenant can be evicted even if the sheriff has not given them those court papers in their hand. If they got the court papers through another means, if they were left with someone else at the property, or if the landlord went to posting and a copy of the summons was only mailed to the tenant, the court can still proceed in those cases to enter an eviction order, and that order can be enforced by the sheriff. So what should a tenant do if they think an eviction case has been started against them, but they haven't yet gotten a summons from the sheriff or from anyone else? If a tenant thinks that a case has been filed, there are resources that are available. First, they can contact the Rentervention, or they can contact the Cook County Legal Aid Hotline for assistance in determining whether a case has been filed. Tenants can also take action themselves and go online to the website for the Cook County Clerk of Court, and they can search the online docket for their name or for the landlord's name and try to determine whether a case has been filed on their own. The slide here shows the online case search screen on the clerk's website, and a tenant can click that Start Search button to form a search for a case that may have been filed against them. Tenants are also sometimes made aware of an eviction case because they receive a mailing from an attorney offering to represent them in an eviction case that's been filed. If you do get a letter from a lawyer saying that there's an eviction case against you, that letter may include a case number which can help you perform your search and find out information about the case. To learn more about the eviction process and what tenants should do to prepare themselves for court, please look at the next section in this series for more information. Thank you.